Yeah, hatred and envy, don't let it tempt me. I move defensive. Evil offends me, I yell repentance. We come from trenches. I'm in the secret place of the Most High, you can't offend me. Hamashiach built many mansions, that's where my rent be. Father, help me overcome. People who I used to look up to, they turning foes for none. Father, you my strength and you my courage. I feel both for some. I wanna feel your spirit on my body like it's clothes or something. Put my vision in your one direction like it's froze or something. I can feel the hatred in their heart is like I owe them some. Yeah, they full of nerves like my hands or my toes or something. No nervous system, but you know I feel it like I'm holding some. Stay in my lane. Anyway, I spin it like I bowl or something. As if I need them for my elevation, like they rope or something. Anyways, I'm too high up your spirit like I'm rolling some. Son of the Most, I pay my dues forever, owe you one. Yeah. If it wasn't for your presence, I would have no peace, believe it. See, that Bible is my weapon, I don't have no beef, I'm vegan. Yeah, your highness, you a blessing, you a masterpiece, I mean it. And I'm fighting for your presence, full of passion, cause I need it. Father, will we make it in? Once we face the end, I'll be looking for your grace within. I've been studying through Corinthians and Galatians. I done found the faith within. The end is so close, you can physically see it. How real is this realm if you can spiritually live it? America so wicked, it's like living in Egypt. And our souls not like them, we out here living with demons. They got Jacob in their blood, but they spiritually heathens. I guess we ain't learned nothing from the Garden of Eden. I guess the Father who in heaven made us all for no reason. I guess if you disrespect him, you are part of the reason. They don't understand what I'm saying, it's a lot. People from my past feeling salty, I'm like, lot. They thinking they could take me up my path, I'm like, nah.
Every election. So now, because they can't beat me, they got to do this smear campaign to convince public opinion that I'm bad for them.
So you said 2 elections, you were first.
Every election. So now, because they can't beat me, they got to do this smear campaign to convince public opinion that I'm bad for them.
So you said 2 elections, you were first elected in 2021?
No, 2013 was my first election for trustee. I was a trustee. I sat where they are.
Right.
That's why I know the law.
Council.
Yes.
Elected mayor 2021.
Yes.
Terms 4 years?
Yes.
Okay. Plans of running for re-election?
I'm running for both my seats. And I'm going to win them.
So, and when is the election for Thornton Township?
2025.
So those elections at the same time?
They are.
Bullshit. A bullshit. A bullshit. A bullshit.
Okay, next.
A bullshit. A bullshit.
I could not be here breathing and be comfortable if I was really as bad as they was making it. You know, nobody could be around me. So for me to be this calm, I must have some kind of inner peace. And my inner peace is knowing that once everybody take the time to really see what type of person I am, you'd be surprised that I stuck around this long. I have to make the life that I do live as happy as I can and try to do the best with what I have. You know, live the best life I can live, be as happy as I can be. Nothing is perfect for anybody. I don't know.
Boys, I swear, I think I figured it out. You know why they don't want us redneck brothers and sisters and the hood brothers and sisters getting along? You know why? Because we'd be unstoppable. I'm telling you right now, we would shut shit down.
Right. We will shut shit down. Let me get myself on the screen. Blessings, blessings. Okay, the camera close. I love you guys. Welcome to Uncensored Enlightenment Talk. I just got my setup back together from me traveling. So bear with it. I think I like this. I'm closer to the screen. How are you guys doing? All right. Today we have a special live. Okay. Guess what, guys? I've been doing so much. I almost missed out on this, and y'all almost missed out on this. Now, I did know that there was something on the warrant list that highlighted a discussion about CAMIELLA Williams and possibly receiving a settlement for about $30,000. And that's what we're here to do our pre-live before. It looks like the camera is lagging. Hold on one second, guys. To do our pre-live before the actual Dolton trustees meeting. Please put in the comments. Let me know if it's lagging. I feel like it's like weird looking. If it's lagging, let me know. I'll pull the camera back. I hope you guys are having an amazing day. This little boy is hilarious. Bullshit. Bullshit. Welcome, Valerie. Welcome. Javar, welcome. Ladies and gentlemen, the Dolphin meeting. They said the Dolphin meeting, hold on, will be today at 6:30. Yeah, definitely. So we were trying to we're getting through this live before then, because y'all know I'm gonna be having a watch party now. I don't know who stream I'm gonna be streaming from, which y'all know we're gonna have a little fun for a second, get into it. And I think we need to celebrate a little bit, because if they get all of these things through on the warning list, baby, the online Dolton resident, myself, I'm gonna be excited. I know you're gonna be excited, because they're trying to put the El Stapo on here. And to my someone making me aware that Tiffany may not show up. And I was like, why won't she show up? She may not show up. She don't show up for these special meetings. Let's see what happens. So this may be an easy peasy pumpkin breezy meeting today. Okay, so I want to get on the screen what we're going to be talking about, and this is actually motion to approve settlement. This is number C on the warrant list. Motion to approve settlement of Williams versus Dolton. They say Dolton of Dolton. It's supposed to be Village of Dolton, and this is the case number, and the amount is $30,000, and it says trustee house. So I was made aware that the trustees were able to get all of or what they wanted on this warrant list. So we're going to get to it. So this is what we're going to be looking at. We're going to look at this again just before the actual Dolton meeting. So, we can go over that. That's going to be commentary before the Dolton meeting. But today, that's what we're going to be going over, this actual case. So we're going to do a case read so you guys can know what Dolton is actually settling and why they're settling. If you don't know that this particular case is connected to my third daughter, and yes, I have adopted her. I have adopted Alexis Wilson. Yes. My soul and my heart. I'm not going to get into it, but I'm going to tell you now, I'm very possessive and I don't play with my kids. So this particular, and y'all going to hear a lot about Alexis Wilson continuing for this year. We have a lot to unpack. Okay, so keep your eyes open. But this particular case is actually connected to her protests. There were protesters that were actually arrested during this time. So we're going to play this video for you. And again, we're going to put my third daughter on the screen so y'all can always remember, say her name, Alexis Wilson. We're going to make her name trend, okay? The Dolton police station will have to pay for all they did. And it's not just to her, but numerous cases that we're going to go over on this channel and highlight directly related to this lady. Yeah, this one right here. I'm trying to be nice. And also her unlawful tactics, as we went over in the last case from 6/6/2024, where a former officer is suing Dolton because of officers being promoted when they didn't have the qualifications. Not only the qualifications, they didn't pass the test. Okay, so if you don't remember that case, please check it out. We'll put it into the end screen for this. All right, so let's put our man of the hour. He is just infamously missing. Okay, and we're going to address this later on because somebody going on administrative leave. Oh, is he going on administrative leave as well as Keith Freeman? I'm talking ahead, but I think that's what I remember. We're going to get to that the next slide. Let's put his old bucket head, thick leg, Lacey on the damn screen. Hit the like if you hate thick leg Lacey causing all this damn trouble for the village of Dolton. Okay? All right. So let me just give y'all a quick flashback of actually what happened if you don't remember, and then we're going to get to the case. God be the glory. I almost missed out. Y'all almost missed out on this because I was like, who case is this? I had to get it together, y'all. It's just a lot of things going on. But I'm just staying positive and staying focused. Let's go.
Right now, a protest over this highly charged surveillance video ends with arrest tonight. Last month, a woman drove off, dragging a Dolton officer before police shot and killed her. That's
not true. I'm just going to remind y'all know that is not true. That officer leg was not severed. I got the proof, the video, and all types of stuff. He was whole when he went to the hospital. And we're going to continue to change the narrative here. But let's go.
Let's get right to Charlie DeMar, live in the south suburbs. Charlie.
Erica, good evening. And Chicago Road is back open tonight. Police did have it shut down for some time as Village provided to CBS 2 show. Cell phone video provided to CBS 2 shows some of those arrests. Dolton police says the crowd crossed barriers and police lines that were set up, and that's when the arrests occurred. Protesters we spoke with say they were peacefully demonstrating on the sidewalk. It all happened near 142nd in Chicago, just a block or so from Village Hall. Several police departments were called in, including state police. We spoke with CAMIELLA Williams, who says she was one of the people detained and released tonight.
He told me I was arrested for disturbance. So I got some disturbance charges, and, you know, I feel like my rights to protest was infringed on.
Step out of the car. Step out of the car. Police were called to a fast food restaurant in July where workers said Alexis Wilson in the red van wouldn't leave and was threatening workers with a weapon in the drive-thru. The passenger in the car got out, but Wilson did not. Surveillance video shows that she drove off and
I'm gonna stop right here because this gets me mad. The lie. I wanted to highlight the protesters getting arrested. Let me remove this off the screen before I get upset. You know, we're gonna play the narrative. We're gonna play the correct narrative, and you know that was a whole lie. So we're going to just play this 40-second clip of father of Alexis Wilson, 19-year-old, says police in Dolton have not given him answers about his daughter's death. And until this day, we're going to highlight this because I want to send love and blessings out to Alexis Wilson, father. You know, from my knowledge, it's been hard for him to speak at the events. And he actually spoke at the last event. And God be the glory to him. You know, as time goes on, healing comes slowly but surely. But as I mentioned, please continue to send love and blessing to this family because they still have not received any resolution or retribution. So let's listen to what he has to say. 40-second clip, and then we will
tonight. New details about the deadly shooting of 19-year-old Alexis Wilson in Dolton. Wilson's family provided CBS 2 with these pictures of the teen. Just hours ago, Wilson's father spoke out, saying he found out about his daughter's death after seeing a story on the news.
All we want is justice, man. And they still, the Dolton police have still not told me who killed my daughter.
It started as some sort of confrontation in fast food drive-thru. Then when police arrived, a male passenger got out of a van. They say Wilson then sped off, hitting a squad car, dragging an officer. Another officer fired several shots into that van. It plowed into a bicycle shop.
All right, we're going to stop right there. You know that narrative is not correct, but let's move forward because I don't want to get distracted. Now, let's get to 3 arrested during the protest. Let's see if it's anything a little bit different here. I want to play both. I'm going to let y'all, we're going to listen to both Fallons. Okay. And the reason why we're going to listen to both Fallons, one is 12 minutes and one is 12 pages and one is 23 pages. The reason why, because you're going to see a change in the tone of how they addressed it first when she first filed it until the second filing, and now it's on the warrant list. Okay, so I'm going to highlight that because I want you guys to know sometimes or most times they try to discredit your grievances, and you have to stand strong. And as time goes on and the law proves or the facts prove, you know, the law is standing, you will win. So I want to show that. Let's get to this article real quick. Let me see if it's anything different that I just want you guys to listen to real quick. Hold on, 1, 2, 3. All right. I haven't been live in a minute, so I gotta get my bearings, y'all. Hit the like button. I appreciate you guys being here. We're gonna continue to fight for Dolton. This is all for Dolton. Yeah, I want to say to you guys as well while I'm streaming live. Do not lose your momentum, Dolton. No matter who's here, who's not here. If I'm not posting, nobody's posting, you're supposed to keep the hope alive. I want you guys to continue to fight a good fight because you guys have been fighting a good fight. You know, and it's been people who you resonate with, you don't resonate with. What it matters is getting the facts and presenting it to the people who can make change. Okay, you have a new chance coming up with this election, and I don't want you just to vote, because I have to stress this. I want you guys to ask questions, the when, the how, and the why. And I do believe that these actions of the police should be questioned. The reason why I feel it's very important, because these police was the same police who was actually one, billing Dolton a high billing rate to add to what were they doing? They were security guarding Hilliard for this particular incident. After the incident of Alexis Wilson, this is when she petitioned to get all of this extra security and use up the police station. And a lot of them went with it. Also, a lot of them terrorized you guys on your property, outside your property, allegedly, and at these meetings. I want you to remember, officers, don't be mad at me. I told you I'm gonna put my foot in your neck for the next couple of months, because some changes need to be made. My concern, and what I'm going to really highlight on this channel, is that police officers and the policies in Dolton need to be corrected and addressed, because your life is on the line. These people are not addressing things correctly. As you see, Lacey did some crazy stuff. We talked about it. We got the video. You see what I'm saying? He did a lot of the crazy stuff that cost Dolton a lot of money, even up to $33.5 million. And you're going to see his name is going to be mentioned in this as well. So I just want you guys to remember, don't forget to ask about your safety. Ask, why are their policy being changed when it comes to policing, and also arrests? Because we also, I just got to, we're going to highlight the Darius Wilson case. I'm trying to set that up so you guys can get a full picture of what we can show to you about that. Okay, guys, your safety is at risk. So please, not only just the finance and the money, but these officers. Because I'm going to add one more thing. I told somebody the only way that we actually helped save Newark was that the police and the community got together. Now, I told you we had road police in Newark, and it was actually the gang and task force unit. Now, when we come to find out, a lot of the regular police, they agreed with us. They was having a hard time, even arresting people, because parents was keeping them in the house, stashing stuff. And then other things were going on that they didn't like, where fellow officers were robbing people, causing more mayhem by dropping drug dealers in other areas. These are stories I told you. But the only thing that helped mitigate the crime and some of the corruption that was going on was that the police and the community got together. We used to start throwing cookouts together. We went, like I told you, stop the violence. When we went around blowing bullhorns Saturday morning, you think they bothered us? No. So I don't contest the police. What I contest is when they don't do what they're supposed to do and they put people's life in danger. So I just wanted to highlight that, guys, the importance of unity between the police and the community. Because sometimes with people with badges and guns, it can get a little dangerous. Okay, let's go.
The family of a woman shot and killed by Dolton police speaks out as video of that deadly encounter is made public.
The 19-year-old was killed just over a week ago.
Tia Ewing is live in Studio 32 with more. Tia?
Well, the family of Alexis Wilson, they questioned why all of the video was not released by police, and they claim she was shot 7 times at close range.
There's a person outside with a gun, and they're knocking on the caller's window.
Workers inside Baba's famous steak and lemonade in Dolton on Sibley Boulevard called for police on July 27th. At one point, the male passenger gets out. In this angle of the video released by Dolton police, you see 19-year-old Alexis Wilson hitting the drive-through window with an object that police say was not a gun.
Yeah, they're here. Okay. I see you guys. Go get that.
The male passenger complies with Dolton police. Wilson pleads with the officers.
What's going on? I'll make you. Cover yourself up with that rope or something.
Body camera video from the passenger side shows what happens next. Wilson's family insists the 19-year-old was punched in the face by the officer.
It can be assumed that it's a punch, but I can't assume that it is, and I can't assume that it isn't.
Wilson's family questions why only portions of the video was released.
We don't have the power to pull body cams. We don't have the power to edit things. This is not a movie. You don't have the right to edit things to make it the narrative you want it to be.
The officer on the passenger side held onto the van as it crashed into this bike store. He's still in the hospital.
Our condolences go out to the family, obviously. And like I said to you earlier, that's absolutely something that no one wants. We didn't want it, and I know they didn't want this either.
A loaded handgun with an extended clip was recovered. Police don't know who that belongs to. Illinois State Police are continuing their investigation. Live tonight, Tia Ewing, Fox 32 Chicago.
Okay, we're going to stop right here. I'm just going to clarify. Y'all see my face. God be the glory. I'm just going to shut up. Pain in my heart. But I will say that officer was not in the hospital long. I did see pictures of the officer in the encounter, and his leg was intact. It was not swollen. I looked at it from a medical perspective. He had no open wounds, no gashes. His pants had a little bit of dirt in it. So just let's just continue to shed light on the narrative. And I'm going to move forward. I just had to let that out because I was getting a little bit mad, and I think y'all saw it in my face. To God. How about that? Now, let's get to the case. Now, what we're going to do is get the AI reader up there. It's going to read the case for us. I'm going to stop it at certain points. I want it to flow pretty good, and I want y'all to compare this first 12-page document to the next 23-page document. So we got about 40 minutes. We can make it through here, and then I believe that it's going to be time to get the Dolton meeting started. So let's get it on the screen. Thank you for tuning in. I appreciate you guys. Thank you, my moderators, for being here. Thank you for supporting me. Thank you for not clunking out. God be the glory. We all here for Dolton. When I make these lives, this is all about you guys. I can't benefit. I just benefit when I see you win. It really touched me. I need you guys to fight. All right. This is, let me change to the 12-page document. I pray that we could get through it. I'm not going to stop too much because I want to get through this in an hour. Well, before the meeting starts. Let's go.
In the United States District Court for the Northern District of Illinois Eastern Division. CAMIELLA Williams. Plaintiff. Case No. 23 CB 5670. V.
Hold on, y'all.
Judge Robert W. Getleman. Judge Robert W. Getleman.
Okay.
Memorandum Opinion and Order. Plaintiff CAMIELLA Williams brings the instant 10-count complaint against the Village of Dolton, Tiffany Henyard, the mayor of Dolton, and Dolton police officers Lacey and Jane Doe 1. Count I alleges that officers Lacey and Jane Doe 1 violated the First Amendment of the U.S. Constitution, pursuant to 42 U.S.C. 1983. Count 2 alleges that officers Lacey and Jane Doe 1 violated the Fourth Amendment to the U.S. Constitution, pursuant to 42 U.S.C. 1983. Count 3 alleges that Mayor Henyard and officers Lacey and Jane Doe 1 conspired to deprive plaintiff of her constitutional rights, pursuant to 42 U.S.C. 1983. Count 4 alleges that officers Lacey and Jane Doe 1 violated the Illinois Constitution, Article I, 1, 2, 4, 5, and 6. Count B alleges that officers Lacey and Jane Doe 1 falsely arrested plaintiff under state law. Count 6 alleges that Mayor Henyard and officers Lacey and Jane Doe 1 conspired to deprive plaintiff of her rights under the Illinois Constitution. Count 7 alleges that the village is liable as principal for violations of state law committed by its agents under a theory of respondeat superior. Count 8 seeks indemnification against the village. Count 9 alleges that the village 1. and Mayor Henyard are liable for damages under a theory of Monell liability, and Count X alleges that Mayor Henyard used her authority as mayor to engage in unlawful policy and practices that violated plaintiff's First Amendment rights, pursuant to 42 U.S.C. 1983.
All right, before we get into the background information, I just want you guys to remember. You remember that not that video we put up about them trying to change the ordinance or the policies in regards to protesters, but the trustees stood up and not let it go by, and Officer Collins was trying to put all these restrictions on it. It was related to these same situations. So just go back and watch those videos, because now it makes sense on why they were doing the things that they were doing if you wasn't aware.
Background according to the factual allegations in plaintiff's complaint. Plaintiff is an organizer and activist in the Chicagoland area. Plaintiff alleges that she organized and participated in a protest on August 2, 2021, to demand justice after Dolton police officers fatally shot Alexis Wilson on July 27, 2021. This protest took place outside of Mayor Henyard's house, and afterwards plaintiff states that Henyard repeatedly expressed to several people that she was upset at for organizing the protest.
I'm sorry, wait, I gotta laugh. If they did that in front of her house, I mean, that's trolling. That's funny. I'm sorry. That's funny as hell. I know she was mad, but actually, you know who else they did that to? They did it to Fannie Willis out here as well. Crooked ass Fannie Willis, the DA.
On August 12, 2021, plaintiff states that she attended the village board meeting to express her frustration with the village's response to Wilson's death, but Mayor Henyard allegedly locked the village trustees out of the meeting, thereby preventing the board from reaching the quorum necessary to proceed. Consequently, plaintiff complains that she and other activists could not make statements on the record. Plaintiff further alleges that when subsequent board meetings were conducted over Zoom, Mayor Henyard directed her staff to disable Zoom's chat feature and block community members from making public comments.
I'm going to start right there. I'm just going to add something, because this is something that Ms. Carl Wilson has been saying, that they have been locking her out and other people who want to talk on Alexis Wilson out of talking at the meetings, as well as even coming in. If they took this to trial, Carl Wilson would have been right there like, excuse me, I'm the witness. Okay, because this is something she's been complaining about.
Plaintiff asserts that Mayor Henyard took this action to chill criticism of the and her administration. Plaintiff also alleges that Mayor Henyard eventually implemented a policy requiring people to register to speak so that certain speakers could be excluded. On September 1, 2021, plaintiff alleges that she and 25 other activists gathered near the Dolton Village Hall to protest the DPD's response to Wilson's death, at the same time as Mayor Henyard held an outdoor meeting for homeowners. According to plaintiff, the protesters gathered on the public sidewalks near the Village Hall, intending to approach and participate in the mayor's public meeting and to peacefully demand justice for Alexis Wilson. However, plaintiff alleges that nearly 125 police officers, including DPD officers, arrived at the protest with tactical gear, batons, and tear gas. At or around 5:30 p.m., plaintiff states that the officers refused to allow the protesters to approach the mayor's meeting, and ordered them to back away. After doing so, the protesters continued to protest, chanting, and holding signs. Then, plaintiff states that the officers became increasingly aggressive and continued to order the protesters to move further away. According to plaintiff, Officer Lacey shouted into the crowd in a threatening tone, "Who is the organizer of this protest?" When no one answered his question, Officer Lacey allegedly continued to shout threats, including "All right, y'all are going to get locked up." According to plaintiff, DPD officers blocked the protesters' path to Village Hall. Approximately 45 minutes later, plaintiff alleges that protesters tried to approach Mayor Henyard's meeting by walking outside the blocked-off area, and plaintiff, with a bullhorn, continued to lead the crowd in chanting. However, as the protesters attempted to join the meeting, Lacey told them to move back as officers walked in a coordinated line toward the protesters, threatening them with violence, arrest, and taunting them. At that point, plaintiff 3. Case 1 alleges that Lacey pushed through the crowd toward her, and told her to put her hands behind her back. According to plaintiff, when she asked Officer Lacey why she was being arrested, Lacey did not respond and continued to seize her, stating, "Don't resist." After plaintiff was handcuffed, plaintiff alleges that she asked Lacey again why he was arresting her, and Lacey responded, "I'm shocked at you, you know better, you going to court, and you have some charges coming your way." Then, according to plaintiff, defendant officer Jane Doe 1 stated that she was ordered to make the arrest of, and when plaintiff asked if the order came from Mayor Henyard, officer Jane Doe 1 replied yes. When plaintiff asked why, the officer allegedly stated, "I just do my job." Plaintiff claims that Mayor Henyard directed officer Jane Doe 1 to arrest plaintiff while she exercised her First Amendment rights. According to plaintiff, officers Lacey and Jane Doe 1 kept her in handcuffs for 45 minutes and then released her, dropping the charges against her. Plaintiff also alleges that after her arrest, another protester used the bullhorn to criticize the officers on the scene for their conduct toward protesters, and this protester was also arrested, in addition to 4 other protesters. When DPD officers attempted more arrests, plaintiff alleges that the protesters disbanded and retreated. On October 14, 2021, plaintiff states that she met with Mayor Henyard to discuss the protests and community demands for justice for Wilson. According to plaintiff, Mayor Henyard stated that she was angry at for organizing a protest outside her home. Plaintiff claims that Henyard's feelings of animus toward and other protesters resulted in Henyard's willful direction to DPD officers to restrict plaintiff's ability to protest and participate in board meetings. Plaintiff further alleges that Mayor Henyard and officers Lacey and Jane Doe 1 reached an understanding to violate plaintiff's rights. Plaintiff states that the village of Dolton has interrelated policies, practices, and customs, which include falsely arresting protesters for engaging in protected speech in assembly, using excessive force and falsely arresting individuals without legal justification, failing to train officers on how to appropriately respond to protesters exercising their constitutionally protected rights.
And you know why she failed to teach officers? Because these officers never passed the damn test. They're not qualified. They probably didn't read the handbook. And you hear what they did. They arrested her and then let her go with no charges. That's false. That's false imprisonment. And she ordered it, not at the order of CAMIELLA doing anything illegal. Let's finish that. Oh, wow. Let's go. All right.
Plaintiff states that the village of Dolton has interrelated policies, practices, and customs, which include falsely arresting protesters for engaging in protected speech in assembly, using excessive force and falsely arresting individuals without legal justification, failing to train officers on how to appropriately respond to protesters exercising their constitutionally protected rights, and retaliating against protesters who speak out against Henyard and the DPD. Further, she alleges that the village lacks a policy addressing how officers should engage with individuals participating in constitutionally protected First Amendment activity. For example, also on September 1, 2021, plaintiff alleges that DPD officers disrupted free speech activity and roughly arrested him before holding him for several hours and issuing a false ticket for interfering with a public meeting.
Wow.
Legal standard to survive.
You remember the false ticket thing? Wasn't that in the last lawsuit? And the other cop said that he got in trouble for whistleblowing about that. You see how all of these cases going to be connected and be used as precedent? I'm praying for Dolton. I got you guys. We're going to stay positive. We're going to pray. But y'all going to need a major bailout when it comes to this money. And this is where I think you need to ask the trustees and your next mayor or whoever's running, how are you going to settle all of these lawsuits? Where is the money coming from? How you're going to factually do this, not imaginary do this? And will this fall on the people? Okay, that's why it shouldn't be things known as qualified immunity across the board. That's why we're releasing things like Agenda 2025. I'll put part 3 in the community. I uploaded it yesterday. These plans to control y'all to, literally have these people be able to do whatever they want to do is being planned and executed before our eyes. I just had this sidebar real quick because that drop is in Rumble. I'll put it in the community page. Part 3, Chapter 3 of Agenda 2025. It's the read. You can listen to it. Make it make sense, y'all. You better be wary. But let's stay to this. Let's get back to the facts.
Legal standard to survive a motion to dismiss. A complaint must allege sufficient factual matter.
Now listen to this. This is what I said. I want y'all to listen to the tone. Legal standard to strive to a motion to dismiss. So listen to this. What's going on?
Legal standard to survive a motion to dismiss. A complaint must allege sufficient factual matter, accepted as true, to state a claim to relief that is plausible on its face. Ashcroft v. Iqbal, 550. For a claim to have facial plausibility, a plaintiff must plead factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. ID. Here the well-pleaded facts do not permit the court to infer more than the possibility of misconduct. The complaint has alleged but has not shown that the pleader is entitled to relief. ID. Threadbare recitals of the elements of a cause of action, supported by mere illusory statements.
So what they're trying to say is that she don't have any factual evidence of this. This is what they're trying to say. They said that we can accept things for face value, but where is the facts? Okay, that's what they try to say. Just let's finish listening. Okay, because why is it on a warrant list today?
Defendants move to dismiss count 3, count 4, count 6, count 9, and count X for failure to state a claim pursuant to Rule 12. The court begins by granting defendant's motion to dismiss count 4 because plaintiff, in her response, requests to proceed without these state law claims in the interest of judicial economy. Thus, the court is left to evaluate defendant's arguments to dismiss counts 3, 6, 9. And ex-defendants first argue that plaintiff fails to state a claim in counts 3 and 6 because she has not plausibly pled the necessary elements of a civil conspiracy among Mayor Henyard and officers Lacey and Jane Doe 1. Plaintiff makes similar arguments to support her claims pursuant to 1983 and state law, so the court considers these claims together.
So basically, she said because she made these claims and she is the person that said allegedly she asked who ordered this and they said Henyard. That officer is not most likely not going to testify on the behalf of her. So they're looking at this like basically it kind of falls under circumstantial evidence. And that's why they're trying to throw it out like, oh, you don't have anybody to circumstance what you're saying because everything was being said was from the claimant point of view. This is what just happened. So if y'all don't know what happened, that's what just happened.
And ex-defendants first argue that plaintiff fails to state a claim in counts 3 and 6 because she has not plausibly pled the necessary elements of a civil conspiracy among Mayor Henyard and officers Lacey and Jane.
And that civil conspiracy has to basically have the elements of them conspiring amongst a group of people to defame or hurt someone, or in this case, Miss CAMIELLA. So when she said one person, she asked that one person, it wasn't a group of them that was doing it. She didn't hear, her and Lacey. This is what they tried to do here. This is just what they try to do to throw it out. Okay. So these were in Illinois, how they were just trying to say,
Illinois
she don't have a claim.
Requires similar allegations to state a claim for civil conspiracy. To plead a civil conspiracy claim under Illinois state law, plaintiff must plausibly allege the existence of an agreement between 2 or more persons.
Didn't I just say that? Agreement, like 2 or more people. I know this from the back of my head, and I'm a little tired. It got to be between 2 or more people, and then she has to show that it was them 2, like someone else heard it. It was paperwork or something. But this is how they try to throw it out. But because the village of Dolton, or whoever lawyer this is, they know that this shit was wrong, regardless of her having to prove this. Because I'm just telling you from a legal term, I think the reason why they're going to sell it with her, because they already know it's facts on his face. Okay. Regardless. Let's keep it going. There's like a conspiracy takes 2 or more persons.
To plead a civil conspiracy claim under Illinois state law, plaintiff must plausibly allege the existence of an agreement between 2 or more persons to participate in an unlawful act or a lawful act in an unlawful manner, that an overt act was performed by one of the parties. 6. Case, 1:23 CV
Hold on,
0567
y'all.
document hashtag
Shut up.
pursuant to and in furtherance of a common scheme and an injury caused by the unlawful overt act. See Lewis.
Okay.
In the instant case, plaintiff alleges that Mayor Henyard and officers Lacey and Jane Doe 1 had an understanding to deprive plaintiff of her rights to free speech and assembly by unlawfully arresting her. According to the complaint, defendants took concrete steps to enter into an agreement to violate plaintiff's rights, and conspired by concerted action to accomplish unlawful purpose by unlawful means. Plaintiff asserts that Mayor Henyard's alleged history of hostility toward protesters, and speech that is critical of the village and the DPD, is circumstantial evidence of the conspiracy. Further, plaintiff emphasizes her allegation that Officer Jane Doe 1 confirmed to plaintiff that Mayor Henyard instructed her to arrest plaintiff, and did so while plaintiff was peacefully protesting. The court agrees that plaintiff has plausibly pled claims for civil conspiracy under both federal and state law, which allow plaintiffs to survive motions to dismiss when they allege the general scope and objectives of an alleged conspiracy.
They try to throw, like, basically, since it was generalized, they can throw it out. I want y'all to listen to this, because this is how they tried to possibly present it back to Miss Williams. Like, you ain't got no case because this is allegedly, and long as she hold the fort and the lawyers held the fort, you're going to see what happens.
Next, the court evaluates whether plaintiff has plausibly stated a claim for Monell liability against Mayor Henyard and the village in count 9. The court begins by agreeing with defendants that individuals cannot be held liable under 1983 using a Monell theory of liability. Plaintiff can allege Monell liability against the village based on Henyard's actions as a final policymaker, but even if Henyard were a final policymaker, she herself would not be liable under Monell, which contemplates municipal liability. See generally Monell v. Department of Social Services, 430.
I make that face because basically her lawyer used the wrong case law, but it's sufficient of what the terms was, but it was the wrong case law.
See generally Monell v. Department of Social Services, 438 U.S. 658. Conversely, the court agrees with plaintiff that she has plausibly stated a claim against the village in count 9. Under Monell, a local government may not be sued under 1983 for an injury inflicted solely by its employees or agents. ID at 694. Rather, it is when execution of a government's policy or custom, whether made by its lawmakers or by those whose edicts or acts may fairly be said to represent official policy, inflicts the injury that the government as an entity is responsible under 1983. ID plaintiffs.
So basically, having the law that cause a conflict of interest is not the problem. The problem is that Henyard executed the law under her, saying, you go do this. This is what made this liable. Do you understand? So this was a difference of what she said. Controversially, I agree with the defendant here, because, well, the plaintiff, because of this, not because the law was like crooked, but because of her executing it and saying, you go do this, and not having no legal grounds. Okay.
ID plaintiffs can allege the existence of a municipal policy or custom by alleging an official policy adopted and promulgated by its officers, a governmental practice or custom that, although not officially authorized, is widespread and well settled, or an official with final policy-making authority. See Thomas v. Cook County Sheriff's Department, 604 F.3d 293, 303. In the instant case, plaintiff alleges that Mayor Henyard, in her role as the mayor of the village of Dolton, was the final policymaker for response to the protests, and developed and maintained policies, practices, procedures, and customs of Dolton police officers. Plaintiff explains that Mayor Henyard instituted a policy of retaliating against her critics by chilling their speech and instructing DPD officers to arrest them with deliberate indifference to their rights.
Now, this wasn't a written policy, but this was a verbal policy, and this is what many other cases have said, a retaliatory behavior from Mayor Henyard. So precedence is already set in this particular standing of what she's coming at, them with. She has a history of doing this, even though it's not written. And as I mentioned to you guys, the Dolton trustees actually made sure that those crooked type of protesting restrictions didn't happen.
1999, as defendants argue, the fact that a particular official, even a final policy-making official, has discretion in the exercise of particular functions does not, without more, give rise to municipal liability based on an exercise.
Wait, I just saw somebody said exfoliating because my skin all shiny. Thank you, boo. Not really. I just look. Don't be letting my ADHD kick in. I turn around like, what? Exfoliating. Anyway, let's finish listening. I'm sorry, y'all. You funny.
The court agrees with defendant that plaintiff has not plausibly alleged that Mayor Henyard has final policy-making authority on police procedures, including arrest procedures, police response to protesters, and police retaliation against critics. Even if the court assumes that Henyard ordered plaintiff's arrest in violation of her rights, one unlawful arrest does not necessarily suggest that Henyard has sufficient authority to implement a broader policy of arrest procedures.
Okay, so basically one of the things, not mistakes, but one of the claims she made is that Henyard had made these policies and she's implemented, but we know that it's a silent policy, but it's no written, and she could not implement that without the board, and it wasn't implemented.
Not a delegation of only the final authority to hire and fire. Plaintiff offers no specific factual allegations to support a plausible inference that Mayor Henyard has such final policy-making authority, although the 9.
Oh, she kind of lucky.
Case 1 court notes that defendant's assertion that Mayor Henyard's authority is limited to presiding over council meetings, 65 ILCS 5/3.1-4030.
Okay.
That being said, the court agrees with plaintiff that she has plausibly alleged that the village has widespread, de facto, or informal practices or customs of falsely arresting protesters or other individuals without reasonable suspicion or probable cause.
So this is what I was saying. It is not written policy. So that's why the judge is like, you can't bring that claim and say she has policies and things. But as putting as, de facto, on code, undercover type of, tone, the judge agrees with that.
That being said, the court agrees with plaintiff that she has plausibly alleged that the village has widespread, de facto, or informal practices or customs of falsely arresting protesters or other individuals without reasonable suspicion or probable cause. Failing to train officers on constitutional arrest procedures for protesters, and retaliating against protesters. Plaintiff lists other alleged instances of DPD officers arresting citizens without reasonable suspicion or probable, as well as one other example of DPD officers arresting a protester, Shabir Manji, on the same day as plaintiff. On the other hand, plaintiff has not stated a claim that the village had a practice or custom of using excessive force, which plaintiff does not suggest was used against her during her arrest. Thus, the court dismisses count 9 in part and denies defendant's motion to dismiss count 9 against the village.
Was count 9 excessive force? I think they dismissed that one. CAMIELLA, you kind of lucky because I think the claims and the way she wrote it up, the lawyer, not her, they put a lot of things that was inference and not things they couldn't really prove. So I think that's why a lot of this sound like this tone. And then you're going to listen to the other one. We have about, let me see, we have about 30 more minutes until the meeting start. Okay, y'all, I'm going to be going between different pages to figure this out, but we got 36 minutes before it starts, allegedly. Let's get through this, and we're about to move on into, I think this is page 10. We're getting to the last part, okay?
Last, the court evaluates defendant's argument that plaintiff has failed to state a claim in count X for unlawful policy and practice against Mayor Henyard, pursuant to 42 U.S.C. 1983.
So when they say the person has to state a claim, there's a few times that they said a claim was not stated, meaning you have to show some damages of what happened. Like regardless, even if it's like not physical or you lost money, it could be emotional conflict, emotional distress. And that could actually be connected to a law. So that's what they were looking for here. So the lawyer is lucky right now because this lawyer didn't do too much because he didn't. What's up with them? They don't know how to write a whole damn. You got to state a claim. This is the second lawsuit. Come on, lawyers. Y'all need me as a legal nursing consultant, legal consultant, because I'll be like, wait, something's missing here. Yeah, but let's finish.
Last, the court evaluates defendant's argument that plaintiff has failed to state a claim in count X for
State your
unlawful
claim.
policy and practice. Plaintiff alleges that Mayor Henyard used her authority as mayor of Dolton to instruct the Dolton police to target plaintiff with enforcement action and took further actions to chill plaintiff's speech. As discussed above, plaintiff has not plausibly alleged that Henyard has policy-making authority over DPD enforcement actions and arrest procedures. Yet, the court evaluates plaintiff's claim that Henyard is liable for her alleged conduct in chilling plaintiffs. To state a claim against a municipality for failure to train under 1983, a plaintiff must allege that the failure to train amounts to deliberate indifference to the rights of its citizens with whom the police come into contact. See City of Canton v. Harris, 489 U.S. 378, 392.
Hold on, y'all. I'm sorry.
10. Speech in assembly. To establish a claim for individual liability under 1983, plaintiff must allege that the individual defendant, through her own conduct, violated the U.S. Constitution. See Perez v. Feniglio, 792 F.3d 768, 700.
I'm gonna beat them. The judge, whoever gave them this, they told them what to do. They like, well, all you have to do is basically link your, they said an affirmative link between the action complaint about the official sue. So they didn't write it up too well. This is why it sounds like this, guys. This is the lesson learned. Okay, so this is from 2/14/2024, and this has nothing to do with CAMIELLA Williams. She's not her. It's a lawyer, Mr. Robert W. Gentleman. Shout out to you, sir, but you've been fucking up just a little bit. Thank God that Dolton just tied and dragged out, because if you had Delgado really on it, he would have been giving you a run for your damn money doing this shit. I'm just being honest. I've been watching Delgado. He's slick as hell.
Conclusion: for the reasons stated above, the court grants in part and denies in part defendant's motion. Count 4 is dismissed, and count 9 is dismissed against Henyard. The court denies defendant's motion to dismiss counts 3, 6, and X, and count 9 against the village.
So we kept
Plaintiff is directed to file an amended complaint consistent with this opinion on or before February 29, 2024.
So basically, the judge said you just need to file an amendment claim. Claim to actually amend what you said. You got to actually put what you have been, the liability, what they did, and what's retribution. So he said in these 4 counts, he's going to give them a chance to refile. So that's what happened there. This is a lesson learned to you guys. This is why I teach you guys in my primetime home buyer page, and I'm going to promote it to basically lead your lawyers, because if you don't lead your lawyers, they're going to file all this frivolous shit, do cookie cutter bullshit, and then it's going to be long filing procedures, amend this, amend that, longer time. The more they file, the more they get paid. That's all I'm saying. I know the game. I'll be like, baby, no, you ain't doing this. We about to do this, do this, do this. They be like, okay. Yup. We ain't about to play with you. All right, so we got about a half an hour. Please hit the like button. Bless you guys. This is the case that they're going to be deciding to give the $30,000 settlement to. If y'all don't know what's going on here, if y'all just coming in the middle of the read, this case is directly connected to Alexis Wilson's death. The protester, Miss CAMIELLA Williams, she was falsely arrested or held in confinement because they didn't charge her allegedly, and she's suing that ass. Also, it's like it seemed like a continuation, especially hearing what Henyard said. Like she had a meeting with Henyard, and Henyard said, I didn't like what you did, and things like that, and then continue to try to block her and other people from speaking at the Dolton meeting. But guess what? We don't have to do anything now. And Miss Wilson, my sister. Wilson, my sister. I'm trying to see if I have a picture still up here. Miss Cara Wilson. Guess what? People are speaking for her. Guess what? God is going to make sure that this case is in the limelight. Okay. Because just so happened we had the butterfly release last week. Well, she had the butterfly release in I-10 I'm always talking about we, that's my baby. And now we're talking about this. You see how God is? God is. Y'all gonna get some justice out there. We're gonna ride their ass like a donkey. Now, let me just check how many more minutes we got. I care about this Dolton meeting as well. So let's look. I'm gonna try to get through this. How many more minutes? Let me look at the clock. We got 30. Okay, we can get through this next document. We're gonna slide through all of what we have already read. And we're probably going to get to we're going to get to page 13. Let's see what's going on. Factual allegations. We went through this factual allegations. That's everything that we have read, but I bet you they made the changes now because this document is from 8/18/2023. So that was about almost a year ago, and now we're a year coming up. So she stated she had to state a claim here. Let's get down to page 12. Mayor Henyard introduced policy initiated to severely restrict the First Amendment. So this one right here, they amendment, but they didn't take it out because they had to show some proof of that. She tried it. She tried to restrict people, but what policies did she put in place? The 2-minute mark. Let me see what this say. The ordinance require any person or organization to notify police chief at least 5 days before. Oh yeah, remember this? Wait, did this policy go through? Hold the fucking phone. We watched that and the trustees said no. Listen to this, y'all.
Mayor Henyard introduced a policy intended to severely restrict the First Amendment rights of plaintiffs and others seeking to engage in First Amendment activity in Dolton. 38. On September 7, 2021, defendant Mayor Henyard introduced an ordinance that would restrict plaintiffs' constitutionally protected right to protest in Dolton.
Y'all
The
remember
ordinance
that?
requires any person or organization to notify the police chief at least 5 days before an assembly, which the police chief...
Wait a minute. That was implemented, y'all? It's the trustees said no. Hold up. Let's listen to this.
The ordinance requires any person or organization to notify the police chief at least 5 days before an assembly, which the police chief retains the right to forbid. In the event of a spontaneous or urgent protest, the police chief's decision is final, thereby giving DPD complete discretion over whether to permit assembly. 39. Based on defendant Mayor Henyard's response to ongoing protests regarding Alexis Wilson, plaintiffs understands that the ordinance is meant to prevent them from protesting in Dolton.
That was the ordinance.
Defendant Mayor Henyard's actions intimidated Plaintiff Williams and other GKMC members.
Okay.
And Plaintiff Williams...
This is what I'm going to clarify. I don't think the ordinance was put in, but I think she said she attempted to put the ordinance in. And they have proof through the videos. You remember? We played that. And she attempted, but it failed. So that's what it is. I was like, wait a minute. Let's listen.
Based on defendant Mayor Henyard's response to ongoing protests regarding Alexis Wilson, plaintiffs understands that the ordinance is meant to prevent them from protesting in Dolton. Defendant Mayor Henyard's actions intimidated Plaintiff Williams and other GKMC members. And Plaintiff Williams felt they could no longer exercise their First Amendment rights safely in Dolton as the mayor seeks to make the approval of their upcoming protests discretionary decisions by the DPD. 40. On October 14, 2021, Plaintiff Williams met with defendant Mayor Henyard to discuss the protest.
You see how they added 39 to that? You remember that certain things was missing. I was like, well, they didn't state a claim because they didn't. They was like, it was just her talking and things like that. So she added that she attempted to change the policy here. You see how it sounds a little different? We learning a little law here. You see how it sounds a little bit different because the lawyer fixed it up. Okay? He put some factual evidence that can actually be traced to a video or something that can be shown. Okay. Now I'm like, okay.
Defendant Mayor Henyard, based on her feelings of animus toward Plaintiff Williams and other protesters, willfully directed DPD officers to restrict Plaintiff Williams' ability to protest in pursuit of justice for Alexis Wilson. 42. Defendant Mayor Henyard also limited Plaintiff Williams' ability to participate in public meetings by preventing quorum at the trustees' meeting on August 12, 2021, and changing the policy for public participation in council meetings.
You see how that can be brought up as evidence, even though it's circumstantial and it's hard to make that connection totally because there was so many people going after her. But you see how that makes sense? Now they pulling in the facts. They like, hey, August 12th, 2021, this what she did. This sounds a little bit better, sir. You did a good job.
43. Mayor Henyard attempted to enact retaliatory and inappropriate policies that are chilling and defeating the right to protest because of her animus toward GKMC and Plaintiff Williams' protesting efforts. Given Mayor Henyard and DPD's continued disruption of Plaintiff Williams' efforts to seek justice for Alexis Wilson, Plaintiff Williams fears continuing her lawful activities. The policy and practice failures of the Village of Dolton and the Dolton Police Department lead to the violation of plaintiff's First Amendment rights. The Village of Dolton has been on notice that DPD has constitutionally deficient policies, practices, and procedures relating to interacting with protesters. 44. All reasonable law enforcement agencies are aware that a constitutional right to protest exists in the United States. That DPD lacks policy to address the existence of this constitutionally protected right is a grave deficiency. The lack of policy also demonstrates a practice of DPD officers utilizing complete personal discretion, rather than adhering to a DPD policy, when policing individuals engaging in First Amendment activity. 45. DPD's lack of policy regarding the use of aggressive tactics that unnecessarily escalate encounters with individual leads to increased tensions, and the frequent use of excessive force.
And it led to the death of Alexis Wilson. I'm just going to highlight that, okay?
The long-standing practice and custom of Dolton police officers engaging in unlawful arrests are the direct and proximate cause of the constitutional violations outlined in this complaint.
Let's go.
47. Upon information and belief, DPD fails to provide officers training on constitutional arrest procedures. This has and continues to lead to excessive unconstitutional stops, arrests, and uses of force. Case 1:23 CV0567 A on September 1st, 2021, Shabir Manji was subject to attack from Dolton police officers.
Let's stop right here because this is what I need. Now, this is what you need to hear. These are consecutive cases that happen out there, and it looks like it's dated as far back as 2013. We're going to listen to a few of these cases, and this is what they're bringing to the judge's attention, that it looks like a pattern. This is a great filing. Good job. Good job. Go ahead.
On September 1st, 2021, Shabir Manji was subject to attack from Dolton police officers who disrupted his free speech activity, roughly seized and arrested him, held him for several hours, and issued him a false ticket alleging that plaintiff was interfering with a public meeting. On January 27, 2019, a Dolton police office waiting for food at the same location as Bobby Richardson used provocative language specifically to intimidate Richardson, and after doing so called for backup to unlawfully arrest him. On September 5, 2018, Dolton police officer Lacey threatened to tase Martez Fleming if he did not exit his vehicle. Officer Lacey never stated a cause for arrest, yet punched Fleming in the stomach, tossed him, and searched his vehicle.
This fat bastard.
On August 4, 2017, Elijah Norman was unlawfully arrested when he sat in a parked car with his girlfriend in a park in Dolton. Norman was visiting family members that work in the park, which Dolton police officers knew. Officers ordered Norman out of the car with the threat of tossing and arrested him without cause. On January 4, 2018, Joshua Tellis was stopped by the Dolton police with his minor nephew in the car. Without cause, officers searched the vehicle and found no illegal substances or weapons. Officers ordered the minor out of the car and arrested him following the search of the vehicle.
Now, wait. Oh, sorry. What I'm going to say here is that this dates back before Henyard, but what you're showing is a pattern of incompetency, aggressive behavior, acceleration of circumstances between Dolton police station and individuals or the citizen in, some type of timeline. What I do like mostly is that what they're stating has links to actual documents, like a ticket, like a this. You see what I'm saying? So this could be added proof to this, because that was one of the things that was left out in Pablo's cafe meeting, where they all these officers made these statements about things that were happening and how many times they had to go there, and they were allegedly directly related to Pablo Cafe, but they were not, and they did not have any paperwork. So I'm just glad that they tightened up on this. Let's move a little bit forward, because we want to have at least a 15-minute intro party before the Dolton meeting start. So let's go.
48. Upon information and belief, the DPD does not have nor implements any policies to address how officers are to engage with individuals participating in constitutionally protected First Amendment activity. Upon information and belief, the DPD has not implemented any policy to guide officers on the appropriate way to engage with individuals participating in constitutionally protected First Amendment activity since the unlawful arrest of Plaintiff Williams.
So we're going to have to review that in the Dolton Police Rules and Policies, Procedures document, well, their book, because what they're saying is that they have no policies related to First Amendment rights for them to learn what it is, how to conduct themselves, and what the people could say, can't say what it, because you can't say everything like bomb, things like that, and it cause everybody to, and people get hurt. That is like, you'll get in trouble for that. First Amendment rights, and they supposed to be taught these things. So it's no rules, no policies in the manual, allegedly, according to this lawsuit.
50. Upon information and belief.
So you see why I said this is important for us to watch, because Dolton, you need to talk to your new mayor, the new trustees that's trying to come in. Can we get some, conformity? Can we get a written plan about how you're going to fix this? Like implementing rules and policies for this particular situation for us to have First Amendment right, especially we're in the meeting and you keep changing 2 minutes, 3 minutes, mic off, and shit like that. You know what we've been going through as Dolton residents. Shit.
Due to DPD policy deficiencies and retaliatory conduct by the DPD and Mayor Henyard, plaintiff reasonably fears that she will not be able to work as an activist.
So she sees that she dropped. She sees, so basically, Miss Williams is saying she's depriving her of her rights and her liberty to be an activist because of these practices. That was good. That was real. That was a good one. I like that. She's like, this is my job. Okay. Go ahead, girl.
51. Plaintiff Williams fears that she can no longer safely work as an activist as defendants will intimidate, falsely arrest her without probable cause, and stop her from exercising her constitutional rights of speech and assembly. Consequently, Plaintiff Williams no longer feels safe protesting, a devastating consequence for her as she has been an activist and organizer in her community for nearly 20 years. Case 1:20. Plaintiff Williams experiences increased fear and discomfort in the presence of police officers.
Now you see where she's getting, where she's having damages. And okay, because we about to finish this up, because the Dolton meeting is about to start in a little while. I want y'all guys to get regrouped, come back on the next live, and we gonna have some fun for 5-15 minutes before. But you see how the Fallon changed, and she's basically saying, now I have increased anxiety, discomfort in my job, discomfort when I see Dolton police. This is when you say a claim. Go ahead, girl. Go ahead, lawyer, for getting it the fuck together. Go ahead. Go ahead.
Plaintiff Williams experiences increased fear and discomfort in the presence of police officers. Plaintiff Williams also fears retaliation from police for her role as an organizer and protester in Dolton and other suburban municipalities that cooperate with the DPD. Due to DPD policy deficiencies and retaliatory conduct by the DPD and Mayor Henyard, Plaintiff Williams reasonably fears that she will not be able to work as a community organizer that advocates against police violence in Dolton. 56. As a direct and proximate result of the actions of defendants as detailed above, Plaintiff Williams has suffered and continues to suffer, inter alia, furthering her work's purpose of organizing community members to end over policing and gun violence. 56. As a direct and proximate result of the actions of defendants as detailed above, Plaintiff Williams has suffered and continues to suffer, inter alia, intimidation and fear in.
Go ahead.
Case, furthering her work's purpose of organizing community members to end over policing and gun violence in the village of Dolton.
Okay, so this is the next
42
legal
USC
claim.
1983 violation of the First Amendment, freedom of speech and assembly, intimidation and retaliatory use of force. 57. Plaintiff repeats and realleges the foregoing paragraphs as if fully set forth herein. 58. Count I is alleged against defendant officers Lacey and Jane Doe 1. 59. As described in detail above, Plaintiff Williams engaged in lawful, constitutionally protected protest activity on the public streets of the village of Dolton. 60. Defendant officers retaliated against Plaintiff Williams for engaging in protected speech by subjecting her to false arrest without legal justification. Plaintiff Williams' protected speech was the substantial and motivating factor for defendant officers to detain
You
her.
see how that makes sense?
Defendant officers intended to make Plaintiff Williams and other protesters wary of continuing to engage in protected speech and assembly activities in the future, and specifically to chill their rights as guaranteed under the First Amendment. 62. At all relevant times, defendant officers knew that Plaintiff Williams was engaged in constitutionally protected speech and assembly when they violated her rights. The misconduct described in this count was objectively unreasonable and was undertaken. Count 2, 42 USC 1983 violation of the Fourth Amendment, false arrest. 64. Plaintiff repeats and realleges the foregoing paragraphs as if fully set forth herein. Defendant officers' false detention and arrest of Plaintiff Williams without reasonable suspicion or probable cause violated her Fourth and 14th Amendment rights to be free from unreasonable search and seizure. The misconduct described in this count was objectively unreasonable and was undertaken intentionally, with malice and knowing disregard for plaintiff's clearly established constitutional rights.
Let me just give you a heads up before we get to the third claim. Basically, with a civil claim, it doesn't have to be proven towards beyond a reasonable doubt. It's not a murder case, but it has to be objectively reasonable that what happened, the average person will feel the same. That's how you win a civil case. That's why they said the misconduct described in the count was objectively unreasonable and was undertaken intentionally. So objectively from our perspective. So I just want y'all to know the standards of law when it comes to criminal versus civil, and that's why they use them verbiage. Let's get to count 3. I'm trying to move, y'all.
Count 3, 42 USC 1983 conspiracy to deprive plaintiff of her constitutional rights.
Let me see how she changed this.
Case. Defendant Officer Lacey, Defendant Officer Jane Doe 1, and Defendant Mayor Henyard, acting in concert with other known and unknown co-conspirators.
You see? Now you see how it sounds much different? They name more than 2 people, 1 to 2 people, just because she asked one person and the person said something to her. She never linked it to Lacey. But then she's linking it to Officer Lacey, the defendant Officer Jane Doe 1, and Mayor, all 3 in collusion. You see how they just had to write it over again? That's why I was like, what? Go ahead. Good job. Go ahead.
Defendant Officer Lacey, Defendant Officer Jane Doe 1, and Defendant Mayor Henyard, acting in concert with other known and unknown co-conspirators, conspired by concerted action to accomplish an unlawful purpose by unlawful means. 72. Each of the defendants took concrete steps to enter into an agreement to unlawfully detain and arrest Plaintiff Williams despite knowing that they lacked reasonable suspicion and probable cause to do so. In doing so, defendant officers acted for the purpose of violating Plaintiff Williams's First, Fourth, and 14th Amendment rights. 73. In furtherance of this conspiracy, each of the defendant officers committed specific overt acts, misusing their police powers for the purpose of violating the rights of Plaintiff Williams and the other protesters.
Let's go. Let's get to the next
Count 4. Illinois state law claim violations of the Illinois Constitution. Case 1:23 CV0. The actions taken by defendant Officer Lacey and Jane Doe 1 denied Plaintiff Williams her state constitutional rights to free expression and assembly in a peaceable manner and to be free from an unreasonable seizure as provided by the Illinois Constitution, Article I, Sections 1, 2, 4, 5. And 6.
Let's get to the bottom.
79. The actions of defendant officers were the direct and proximate cause of the violations of Plaintiff Williams' Illinois state constitutional rights.
Okay, so basically these are the same claims, which is unlawful arrest, false arrest, violation of her constitutional rights, which is count 1, as well as conspiracy. So what they repeat what you would have heard is basically her still trying to separate Henyard and also the officers. So she had to name Henyard and then the officers. So that's why the counts seem long. So those are the main 3 counts. Conspiracy, and you see how they had to rewrite it, as well as false arrest, catch and go. They was not supposed to do that. It was no reason to anyway. And you see how they linked the conspiracy case and made them like coerce together. So this was a learning experience. If y'all ever have to sue anybody, make sure y'all know how to write up the complaint, that y'all lawyer just don't put anything and have y'all case waiting for a whole damn year. Okay, so this is what I'm going to do. We've been on for an hour. I hit the hour and 9-minute mark. Dolton, the meeting is starting in the trustees. I'm going to be looking at it through the Dolton trustees page, but I am going to be creeping on other people's page to get different angles. Y'all know what I do. We're going to have a little fun. I'm going to be coming back in 5 minutes. It starts in 9 minutes. So y'all guys get ready. If y'all want to go over there and tune in. Y'all gonna hear the notification from me. Y'all come over, have some fun with Grace Levi. We start celebrating what's on that warrant list, and we get down. We see how far that it goes today. Okay, so what I'm gonna do now is tune out. I want you guys to listen to my Hebrew brothers on the way out. We're gonna take you to church. We're gonna take you to church before we get out of here. I love you guys. Thank you for being here with Grace Levi. See you in 5 minutes.
I could not be here breathing and be comfortable if I was really as bad as they was making me. You know, nobody could be around me. So for me to be this calm, I must have some kind of inner peace. And my inner peace is knowing that once everybody take the time to really see what type of person I am, you'd be surprised that I stuck around this long. I have to make the life that I do live as happy as I can and try to do the best with what I have. You know, live the best life I can live, be as happy as I can be. Nothing is perfect for anybody. I don't know.
Boys, I swear I think I figured it out. You know why they don't want us redneck brothers and sisters and the hood brothers and sisters getting along? You know why? Because we'd be unstoppable. I'm telling you right now, we would shut shit down.
Yeah, スライドする。お前の地元にスライドする。
Imagine if my small business blew up overnight and I woke up to some sales. Boost this video so people who like my products can find me.
Algorithm. Where you at, bitch? Because I'm tired of posting viral content and getting 2.5 likes. We finna fight, ho.
Yeah, お前の彼女とスライドする。